Ms. Irene Quay.
Mr. Deputy Speaker, sir, the Criminal Law Reform Bill could not have arrived in a timelier manner, especially in light of the changing crimes environment in Singapore by virtue of the proliferation of social media and smartphone use. I would like to commend the Ministry of Law, Home Affairs and PCRC for working unceasingly over the past 20 years, soliciting feedbacks from various sectors, both private and public, from judges, private practitioners to academics, police, as well as public consultation from selected groups and social organizations within working with vulnerable victims. The outcome of the bill is one that is relevant, practical, and well-calibrated to ensure that the vulnerables are protected and the resulting punishment accurately reflect moral culpability. I'm very heartened to hear that the latest changes repealed marital immunity for rape and introduced higher penalty for offences knowingly committed against vulnerable victims. This also includes charging members of the household guilty of offence for causing or allowing the death of a child under the age of 14. While we have a comprehensive, robust bill to protect victims from criminal offenders, it is contingent upon us to constantly look for ways to facilitate the reporting of domestic violence. The reasons for not reporting can be complex, as they range from social, psychological, financial consideration to the ease of reporting. I would like to take this opportunity to laud the Ministry of Social and Family Development for their considerable efforts over the years to introduce more vigorous screening tools, training more professionals in operating these tools, and creating more public awareness towards these issues. Their endeavours has led to enhanced detection, reporting, and management of child abuse cases, resulting in very significant increase of 60% in reporting. However, there's always room for improvement. A quote from social workers from a Straits Times article in 2017 has indicated a disparity where, when a child is abused by a stranger, family members are quick to report. However, this is not so when the abuser is a family member. In recent years, there have been a trend of cases involving children dying or severely traumatized from brutal, chronic, physical, psychological, and sexual abuse in household. And to hear of this is absolutely heartbreaking. It is also very distressing that most child abuse cases in Singapore involve caregivers. In 2015, MSF was quoted by the new paper stating that in the 64 cases of alleged sexual abuse reported and investigated from January to September 2015, for every case, the alleged perpetrator was a family member or someone residing in the same household as the victim. These cases often go unreported as victims are afraid that the family may be devastated. The victims more than not are unable to fend themselves or are too afraid to come forward to seek help. As such, it is of paramount importance that members of the public, such as the neighbours, relatives and friends, are encouraged to come forward to identify victims of family violence. In a similar vein, spouse abuse is one of the most common forms of family violence in Singapore. A study by the organization based on 3,600 cases over the past 10 years found that victims who are physically or psychologically abused by their spouse make up a disquieting 72% of new cases. In the interest of reducing prolonged cases of domestic violence and abuse, I request that a central dedicated hotline be set up with trained personnel to handle all domestic violence calls. Concurrently, a standalone app or feature should be introduced in our current municipal apps such as the One Service or SG Secure to handle all social abuse ranging from child, spouse, elderly, or other vulnerable groups, and even include animal abuse, to allow for a more coordinated response. This way, victims do not have to be routed to various touch points and repeat their accounts. This dedicated hotline and app can be designed to offer all victims of domestic abuse immediate relief from their plight in 3 stages. Firstly, through crisis intervention and counseling. Next, indoctrination and actions on the various channels of recourse, and consequently, a successful resolution and rehabilitation. Our current system requires victims to call various resources at different hotlines, which is confusing and can be a deterrent. The staff working at this central hotline or app can be trained in crisis intervention and will be assigned to individual cases to build rapport with victims through counseling. They can then coordinate with local resources such as the police, hospital, or pro bono legal aid for a more integrated victim-centric care. The staff can then work out a personalized safety plan which will include how to receive financial assistance and how to gather evidence of abuse if the cases go to court. In the event the victim cannot continue residing in their home for fear of continued abuse, coordinating staff will assist to put them up in a temporary shelter and seek protection order on their behalf with their consent. Victims can also be directed to websites such as the Aware through the app, where information on domestic violence education can be found. This is if they feel the need to consider their situation before taking further action. It is also vitally important that an algorithm be implemented in the app to separate the more urgent cases and triage victims who require immediate medical attention from abuse. Through these processes, victims will be able to chart their journey towards restitution and rehabilitation should they choose to lodge a formal report. They will also be educated on frequently asked questions and fully assured that there will be no backlash from their abusers. There have been many precedents where victims have successfully sought recourse through lodging a report, and these inspiring stories should be made aware through the app to encourage reporting. This central hotline and app can also be a platform for members of the public or bystanders to report abuse cases with anonymity and an avenue where they can be taught how to help victims of abuse. However, while most do not report such cases to the authority or hotline, many may want to seek advice or information for family members or friends. Having a standalone app or a secondary municipal app feature will be useful in encouraging reporting or seek information on how to help abuse victims. Members of the public may be more comfortable making a report online compared to calling a hotline. There are many examples of such apps available overseas, and their features which can be used as reference. The Smart Safe app by the Domestic Violence Resource Centre in Australia or the Bright Sky app by the UK Charity Board are a few examples. These free apps help women collect detailed evidence in order to obtain a protection order or prove a breach of one. They collect photos, videos, and recording and save them off-device to ensure that the evidence is protected and can be used in court later when victims are ready to lodge a report. The DAISY app in Australia provides information about support services within vicinity and includes safety features to help protect privacy of people using it. In the United States, the Sojourner Peace app is available in multiple languages and provides resources for victims of domestic abuse in a quick and discreet way. It also provides links and phone numbers to places where survivors can seek help and access to the Sojourner 24 Hours Domestic Violence Hotline. To recap and emphasize, an app mentioned above will greatly benefit victims of domestic abuse and facilitate the ease of reporting for abuse cases. By adding features such as discrete evidence gathering, a one-touch police alert option, and a central hotline number, we can ensure that every service is synergized to provide the best protection and survival-centric help to all victims of domestic violence in Singapore. Notwithstanding my above points, I stand to support the bill. Thank you.